The principles on which a court must adjudicate a matter for passing interim orders are primarily balance of convenience and irreparable harm. The judgment of the Supreme Court in the challenges to the Waqf Amendment Act 2025 falls short of these parameters. First, let's look at the directions which have been given by the Supreme Court. It reminds me of the adage, the Lord giveth and the Lord taketh away. Each of the directions which have been given have been watered down by caveats and disclaimers which take away a lot of what was granted in the first place. For instance, the requirement that a Waqif must have been practicing Islam for 5 years has been stayed only until rules are framed by the government, laying down parameters for how practice of Islam is to be judged. Secondly, the induction of non-Muslims into the Central Waqf Council and the State Waqf Boards has been recognized to be excessive. However, it has been limited on the statement made by the Solicitor General that not more than 4 members in the council and not more than 3 members, non-Muslim members in the Waqf boards will be appointed. The question which was not adjudicated is why should there be even one non-Muslim in these bodies, particularly considering that for all other religious charitable endowments, this requirement does not apply. For instance, Sikh Gurudwara Prabandhak committees are supposed to comprise exclusively of Sikhs, and Hindu religious endowment boards are supposed to comprise exclusively of Hindus. The only example that was sought to be cited by the central government of the Bodh Gaya temple is inapt because the act there says that the managing committee must comprise of both Hindus and Buddhists for the reason that both have devotion to this temple. So that in fact strengthens the argument that non-believers are not to be placed into management of religious properties, and that's a violation of Article 26 of the Constitution, which allows a religious community the freedom to manage its own properties and its own affairs in matters of religion. Now, another provision which has not been considered even for stay is the proviso to Section 2, which says that any property which was at any point of time registered as a trust under any trust law will be outside the purview of the Waqf Act. What this does is that in states like Maharashtra and other states where for the longest time there was no Waqf board and all Waqfs were being registered as charitable properties. For instance, in Bombay, the Bombay Public Trust Act is where all Waqfs were registered, and as a consequence of this order now, all trusts in Mumbai will fall outside the purview of the Waqf Act. To take an example of what the consequence of this will be, Antilia, Mukesh Ambani's house, which was purchased from a Khoja Ismaili Waqf, which was being run as an orphanage and which was being litigated on the question of whether it could have been transferred in the first place, has now fallen outside the purview of the Waqf Act, and once the property is deemed to be trust property, it is transferable. This question had already been settled by the Supreme Court when it had said that irrespective of the form in which a Waqf is registered, the intent of the Waqif and the purpose of dedication will be what will be used to adjudicate whether property is Waqf or not. That is why the amendment begins with the words, notwithstanding any judgment to the contrary, thereby overruling the Supreme Court decisions in Nawab Zain-Yar Jung and Sheikh Yusufbhai Chawala, where the Supreme Court had laid down this principle. Legislative overruling of Supreme Court judgments is not permitted, and this is not a point which has been considered at all by the Supreme Court while passing the present order. Section 107 of the Waqf Act, which was deleted, which said that limitation does not apply to Waqf properties, that has not been stayed. That deletion has not been stayed. As a consequence, anyone who's been in encroachment of Waqf property for more than 12 years will become the owner by adverse possession, and that property will be irretrievably lost. So this, if anything, is irreparable harm. The court said that why should limitation not apply to Waqfs since it applies to everything else, but that itself is an incorrect understanding, because limitation also doesn't apply to Hindu religious endowments under Hindu religious endowment laws of Tamil Nadu, Andhra Pradesh and Telangana, to take some examples. Another important provision that has not been stayed is Section 3D, which has been introduced in this amendment, which says that ASI protected monuments will be outside the purview of the Waqf Act. Now, for this we have to understand that the Ancient Monuments Act 1958 is a statute for protection and preservation of heritage, whereas the Waqf Act is a statute for ownership and control. The Ancient Monuments Act doesn't necessarily require that the property must be owned by ASI. It has various models of protection, which include entering into an agreement with the owner or occupier for preservation of the property, or passing directions in case such an agreement is not entered into, with laying down do's and don'ts that the owner and occupier are bound by. The court has said that Section 5, Subclause 6 of the 1958 Act permits citizens to continue their religious practices, and therefore there is nothing that the Muslims are losing on account of Section 3D. Now, this is not true because the court fails to take into account that already there are suits such as the suit concerning the Jama Masjid in Sambhal, which is pending, and a writ petition has now been filed concerning the Bija Mandal Mosque in Madhya Pradesh, where the Hindu side is saying that the property must be taken away from Muslims and they must be given the right of access under the Ancient Monuments Act. Therefore, there is actually an immediate change in status which is threatened by virtue of Section 3D of the now introduced Waqf Amendment Act 2025. Even under the 1958 Act, if any property is to be acquired by ASI, that has to be under the Land Acquisition Act and fair compensation has to be paid. So what this amendment in fact does is that it takes away the ownership and control of the Waqf from the owners and occupiers without payment of compensation, and that is contrary even to the provisions of the 1958 Act itself, and is a gross violation of the right to property which is enshrined in Article 300A of the Constitution, depriving Muslims of the ownership of property without payment of compensation. Another provision which has not been stayed is Section 3E, which says that Muslim members of scheduled tribes cannot dedicate Waqf property. Now, this is a gross violation of the right to religion under Article 25 and the right to manage their affairs in matters of religion and their properties and their religious properties, which is enshrined in Article 26 of the Constitution insofar as Muslim members of scheduled tribes are concerned. The requirement of compulsory registration of Waqfs on the Waqf portal has also not been stayed, and the consequence of this is that the Act provides a time frame of 6 months within which these properties have to be registered. Now, the judgment was on the interim orders was reserved by the Supreme Court on May 22nd, 2025, and it's now almost 4 months later that the judgment has been pronounced. So 4 of the 6 months have been spent in just waiting for the judgment, and that now leaves very little time from the date of commencement of the Waqf Act, which is April 8th, and on October 7th, that timeline expires. This time has been spent in awaiting the judgment of the Supreme Court. As Seema Akbarabadi said, umre daraz maang kar laaye the 4 din, 2 arzu mein kat gaye, 2 intizar mein. So where this places the Muslim community is that the time has run out and the requirement of registration is now running into its deadline. Since the interim order is disappointing for the petitioners, we now have to await the final adjudication of the petitions, and now it remains to be seen which Chief Justice of India, as master of the roster, will constitute a bench and list these matters for final hearing, because otherwise, like the challenge to the Citizenship Amendment Act, which has not been heard in the last 6 years, if this goes into cold storage, then permanent harm and irreparable injury will be caused to Waqfs in India on account of the provisions which are now in force.